Welcome back, everyone, to OpenLine. We are talking about elder law. We have with us Chris Johnson, attorney with Takacs McGinnis. He's joining us via Zoom from their offices up there in Hendersonville. As we went to break, I said we would talk about trusts. And I know, frankly, I don't know tons about trusts, but I know sometimes you all get very excited when I talk about trusts. So what's the deal with trusts? What do we need to know?
What you need to know is real simple. And so for the listening audience out there, the big thing is, let's start with the basic trust, the revocable living trust. I think that's the one most people are familiar with. And what that is, when you hear revocable living trust, you should think one thing: probate avoidance. That's what a revocable living trust is at its basic, most nebulous form. That's what it's meant to do. Can you build it out? Can you do some other things with it? Absolutely. But how it works is, when you go to probate, you own something at your passing, and because you've passed away and a dead person can't own something, and you haven't otherwise designated, made it payable on death, or made it a joint account or something else, so it doesn't have any ownership at that point. So the court will create the estate of. So Ben, you pass away, and the court's they take your will, they go to probate, they're gonna create that legal fiction, the estate of Ben Hall. And that estate owns your property during that transition time. And then it's gonna follow the instructions on your will, pay your creditors, pay your lawful debts, and a final tax return. Once all that stuff's taken care of, it'll make distributions. Well, the revocable trust is in and of itself a legally recognized entity. And so you deed your home in the trust, you make your bank accounts payable on death to the trust, you make your stock investment accounts transfer on death to the trust. And when you pass away, that trust, think about it like a big bucket. Did it catch all of your stuff? And if everything's in that bucket, well, now we have no need to go to probate. Why? We have a recognized legal entity that owns everything during the transition. That trust will have a trustee that you named. So now we have the revocable living trust of Ben Hall, and you have a successor trustee because during your lifetime you were your own trustee because it's all your stuff. You passed away, and maybe it's one of your children, maybe it's one of your siblings. They're the trustee, and they're going to read that trust, and that trust is an instruction manual. It's still going to say those same things: pay my lawful debts, pay my creditors, take care of final arrangements. And when it's done, then you're going to have instructions. Here's how I want my estate to pass. And the nice part about the trust is your estate doesn't have to pass instantaneously. Maybe you have a child who's 18 or 19 years old, and you're thinking, listen, if they get a big check at 18 or 19, this might not end well. I think I want the trustee to hold that money. Well, it's true.
That is true. No, that's a good point.
I joke with my clients. At 18 or 19 years old, I was ill-equipped to handle a large sum of money. I don't think I would have handled it well. People pick on professional athletes sometimes and say, oh, look, they blew that money. I think it's impressive how many of them don't blow the money. I mean, none of us, I think, at 18 or 19, or very few of us, were really emotionally equipped and with a maturity to handle that kind. And so the trust can provide a lot of levels of protection. If you have a disabled child, you can hold that money in trust for. There's all sorts of things you can do. But eventually, hopefully, everything passes to where it should be, and then the trust terminates because there are no more assets in it. Now, there's different types of trusts, and so you can do asset protection trust, put a home in an irrevocable trust to help for Medicaid planning, to help for VA planning, and that really at that point, and that, again, that would be a whole nother show in and of itself, but the key is that you're choosing the right trust for the right job. And it's like having a tool. For anyone who's watching, who's handy, and they've got a good tool collection, they use it. One of the worst things you can do is bring the wrong tool to the job. You're going to be mad, you're going to be cursing, you're going to have, wrapped knuckles as you're, banging them on things. One of the best things you can do in life is bring the right tool to the right job, because it makes the job easy. The same thing is applicable in trust planning when you're doing someone's estate. We want to make sure we're bringing the right trusts or the right tool. I actually had someone, I was talking about probate avoidance, speaking of using the right tool, and as I'm going through all the pros of it, and I'm saying, listen, you don't have to go through the court system and the judicial scrutiny and all this. And they looked at me and they said, Chris, if you knew my family, I think having a judge keeping tabs on this would be the best thing that could happen to them. And I said, let's do a will. And they loved it.
Well,
yeah, because for them, the will was the right tool. And so you can't just say a revocable trust is better or a will is better or an irrevocable trust. You have to know their circumstances and you have to know what their goals are. And you got to build out the plan that matches what their needs are.
We start talking about trust and we get calls. Let's go to Harriet here.
Oh, there we go.
Hello, Harriet.
Hey, y'all, I've got a quick question for your guest there, Mr. Hall. How come credit unions cannot be transferred over into a trust, or a revocable or irrevocable trust upon death? Why do you have to have a regular bank account? That's what I've been told. I'm going to hang up and listen to you real quick.
Oh, all right. What about that?
So Harriet, that's a great question. There probably were a few more. I wish you hadn't hung up so quickly. If it's just a regular checking account or a savings account at the credit union, you shouldn't have any problem. There's different ways of getting that asset into the trust. And so one of the first ways is you could just ask that the account be retitled into the name of the trust. So I have lots of clients that'll take their checking account and retitle it into the revocable trust. One of the things I caution is when they retitle an account, they're going to give a new account number. And so sometimes what might have happened is someone cautioned you not to do it because it's going to cause disruptions. All of your auto bill pays will be severed. The big one for a lot of our clients are they have a checking account. They're like, well, why don't I just put it in the trust? And my first question is that where your Social Security check goes? And they'll say, yeah, it does.
We actually have to break. Harriet, thank you for calling in, Harriet. I wish we could have talked longer. I hope that answered your question. Okay, we got to take a break. I'm sorry. We'll take a break. Be back right after this.